Hello everyone. On behalf of the NBSAP Forum, I want to welcome you all to this last session of our March webinar series. I am Diego Ochoa, NBSAP Forum Communications Advisor, and thank you again for attending this webinar series dedicated to legal preparedness for implementing NBSAPs. Our fourth webinar in this series is, I have some technical problems here. I'm sorry. Okay. Our last session of the webinar series is in charge of Barbara Lausche from the MOTE for the Marine Policy Institute. Marine environments are some of the most biodiversity rich on the planet. Moreover, the oceans provide services and functions that are fundamental to human life and livelihoods. The main purpose of the Convention of Biodiversity Conservation, Article 6, requirement for countries to do national biodiversity strategies and action plans, is to serve as a framework for national strategies, plans, and programs for biodiversity conservation and sustainable use that are integrated into relevant sectoral or cross-sectoral plans, programs, and policies. To safeguard marine biodiversity and the important functions the oceans provide, the creation of marine protected areas and other supportive marine conservation strategies is essential. Such protections must be grounded in law with tools supporting a range of protections from strict conservation and sustainable use to connectivity conservation. In support of NBSAP, this webinar focuses on special legal elements needed for marine biodiversity conservation, taking into account the unique features of marine environments with particular attention to marine and coastal protected areas. Marine connectivity conservation tools and strategies also are highlighted for broader area-based marine management because of the critical role that connectivity plays in supporting marine protected areas and sustaining the planet's dynamic marine and coastal resources, ecosystems, and services so critical for life on Earth. This last session of our March webinar series on legal preparedness for implemented NBSAP is developed to support countries to legally prepare themselves to implement the NBSAPs, and it will be presented by Barbara Lausche. Dr. Lausche is staff at the MOTE Marine Laboratory and Aquarium, a nonprofit marine science research organization based in Florida, where she serves as director of its Marine Policy Institute. She is an international environmental lawyer and legal drafter with 30 years of experience, specializing in protected area-related law and associated international law and policy. She has authored or co-authored papers and books on laws and protected areas, including the IUCN Guidelines for Protected Areas legislation. Welcome, Barbara. It's a really pleasure to have you here, and thank you for attending this invitation. Okay, as usual, before starting, I just want to remind you all some rules and our dynamics in the NBSAP Forum webinar series. Microphones will be mute during the presentation. This reduces interferences and facilitates the communications. We will have a 1-hour presentation followed by 30 minutes of questions and discussion. Please send us in advance your questions or raise your hand in the control panel. If you want to speak and the connection allows, we will open the participants' microphones to promote interaction during the Q&A session. As many of our participants are not English native speakers, me included, I would like to remind Barbara the importance to talk slowly. This fosters the comprehension among our practitioners. This session is being recorded and it will be available at the NBSAP Forum website. All the participants will receive an email with a link to watch it, as well as a PDF copy of the presentation and a list of resources related to this topic. Now, I would like to transfer the webinar to Barbara. Please enjoy the session and welcome again, Barbara.
Thank you, Diego. Greetings to everyone, and thank you especially to UNDP for organizing this important webinar series. I want to begin by explaining this picture is a picture of the Solitary Islands Marine Park in Australia. Before we actually start the substance, I want to give some context in where our materials are coming from and the context of the work that we've undertaken for the last 10 or so years to produce materials that are the basis of this webinar, as well as the first one on law and governance and the third on connectivity. The IUCN Environmental Law Center Protected Areas Law Program introduced a new set of projects beginning actually in 2006 to produce updated guidelines for protected areas legislation, and then a supplement on connectivity law to support marine protected areas. Phase 2 is to translate these documents, because they're rather dense and lengthy, into teaching materials that include lessons and seminars for professors to use, exercises for students to apply their knowledge, and videos. The documents, all of these documents, can be found at the IUCN website that you see there. The most important point, I guess, at this point is to mention there are 12 teaching modules. As reviewed in the prior 2 webinars, the first 6 cover basics and generic elements of protected areas law that apply also to MPAs. The last 6 are more specialized in individual issues. Modules 8 and 9 and 12 were covered in webinar 3, and of course I will focus on modules 10 and 11. So let's begin. There are several points I want to start with as take-home points or messages. Hopefully we will all remember as we conclude this and move forward with some of the lessons we learn here. First, MPAs are an essential part of any NBSAP for coastal and island nations. MPAs also need supportive legal frameworks to achieve national and now our new global targets for and international commitments under law. They also have special features and techniques that require special legal attention. That's because of the environments themselves. MPAs and marine environments have special connectivity needs as well that require legal support. And finally, many MPAs and marine conservation areas are outdated and need strengthening to reflect the latest science, best management practices, and international law. And I want to add here that the MPAs are a little bit, legislation is a little bit behind terrestrial legislative updates. It's partly because it has not had as much attention over the years and the decades, and also our science has not been as advanced. So we have some areas where understandings of the marine environment are still in its infancy. Why do we care? I think this is important because it is an issue that is increasingly becoming a scientific topic. We can review, many of us know, the oceans make up about 70% of the planet in terms of surface area and contain 97% of its water. Their ecosystem functions and services are critical for human life. When we get to marine and coastal zones, estimates are that marine and coastal zones provide more than 90% of the biologically useful habitat for life on Earth, including nearly all the major groups of animals, plants, and microbes. In addition, the Millennial Ecosystem Assessment of 2005 found that marine and coastal ecosystems are among the most threatened on the planet. Climate is a factor. Oceans drive the planet's climate and weather and regulate temperature. They generate much of the oxygen in the atmosphere. absorb CO2, replenish fresh water with for both land and sea through the formation of clouds. They supply our food and generate billions of dollars to national economies. So this is my layout for what I would like to do today. It's going to be rather condensed because there is so much to cover, but I again encourage everyone to look at the source materials if they want to get into more detail. Historical development is worth mentioning just briefly because marine protected areas are not a new concept. They were used hundreds of years ago as a management tool for fisheries resources. For example, to protect breeding areas and then protect cultural and archaeological sites, mostly sunken ships. This was mainly initially through traditional and community practices and gradually supported by law. There's been a change in focus over the years. Now we put more focus, because of better science, on protected areas as a key tool for biodiversity conservation. And MPAs have turned to protecting marine biodiversity and ecosystems, as well as incorporating modern governance concepts. There's also been a change in approach as a result of this. The shift is in the broadening significantly MPA's purposes and roles, and including supporting area-based management, connectivity, and restoration. Driven by science, of course, this has become a much more sophisticated and focused effort. Today, we have MPAs under many different names, partly because of the historical development. They could be marine parks, marine reserves, or marine sanctuaries, or even other names. The other area that is significantly moving us forward with MPAs and expanding and trying to improve our understanding of how to make them more effective and responsive are two global targets that have come to us in recent years. The first is the CBD target. Webinar 2 mentioned very, very completely and importantly, the ACHI targets. I would like to focus on target 11, although many of the others apply. This calls for an increasing coverage of marine protected areas by 2020 to 10% across the globe, including in national areas and marine water areas. These areas are to be effectively and equitably managed for ecologically representative and well-connected systems of protected areas and other effective area-based conservation measures, a new approach rather, and integrated into wider landscapes and seascapes. There we have connectivity. Then, just last year in September, the IUCN World Conservation Congress passed a new resolution upping this a bit by saying and pledging that at least 30% of national waters be designated and implemented as MPAs by 2030. And again, including in this cluster other effective area-based conservation measures. Part of that resolution encouraged CBD parties to look at their post-2020 targets and increase them to 30% by 2030. Also, just to briefly note the Half Earth Initiative by eminent scientist and biodiversity evolutionist E.O. Wilson, who has been promoting the Half Earth Initiative, and he presented this initiative at the WCC. This is what I want to say about the evolution to get us started and not take us too long. I want to move next to special features in international law that dictate some of the requirements that we think are very important in marine protected areas. Special features and characteristics are many that we already know. We have three-dimensional space. This is a fluid aspect of the sea, movement of marine organisms horizontally, vertically, as well as across these scopes, and migratory over long distances. We have vastly expanded areas now with the new law, the sea extension of national waters to the exclusive economic zones, basically 200 nautical miles seaward, resulting in national jurisdictions actually for marine areas that may be larger than the entire land area. We have deep water zones. The coastal states now have responsibilities that extend much beyond the coasts. They are faced frequently with insufficient data to understand deep water areas and most high value sites. So here the precautionary principle is especially important. We have large scale connectivity processes underway between coastal, marine, and inland systems. This requires effective management of a marine area that includes adjoining coastal and island areas. We have sharing high sea processes with areas within national jurisdiction. This is biophysical processes, living resources, and they can influence each other. We don't have a wall between national waters and high seas. Then we are faced with limited scientific knowledge. We have marine biota that is still being much under research, and our knowledge is very incomplete for much of the sea. This is true especially for understanding deep water processes, seamounts, hydrothermal vents, and cold water currents. Special threats, we all know. Habitat destruction, of course, comes up as number one, particularly in the Millennium Ecosystem Assessment, which has concluded that coastal areas are among the most threatened on the planet, and the main threat being habitat loss. Unsustainable fishery comes in a close and immediate second. It's one of the growing threats and most immediate threats to MPAs worldwide, directly depleting target species that are overfished and non-target species and endangered species in bycatch. The bottom trawling also hits habitats and causes destruction. In addition, a new and growing concern is uncontrolled sports fishing. Land-based pollution is increasingly occurring as populations move more to the coast. Some estimates more than 60% now living or dependent on coastal zones. Coastal and nearshore biodiversity and aquatic habitats are under stress, increasingly from such elements as domestic wastewater runoff, including agricultural non-point source runoff, industrial point source runoff, sediments, as well from activities involving development. Climate change, now I want to point out again, as was pointed out in other webinars, particularly number 3, is likely to be the most severe and challenging threat to marine and protected areas worldwide. And we can see here the various elements that are impacting our oceans that will be changing the very character of how we work and how they function. Special management challenges, briefly, we are again looking at exceptionally large areas. The establishment of new PAs covering large areas means new management efforts and experiences. We have less experience in this area because particularly management in marine environments is much less developed than for terrestrial environments. Nevertheless, the IUCN categories apply to both marine and terrestrial environments in order for the whole protected area system to be a compatible management framework. We have special equipment needs, particularly for large areas, as widely dispersed areas need monitoring and surveillance. So we more and more need specially trained personnel, special vehicles, equipment, including remote sensing and satellites. We have near shore versus high shore demands, which are different in terms of management, in contrast to coastal MPAs, which are focused on relatively fixed ecosystems such as marshes or mangroves. Offshore MPAs may have more dynamic systems and migratory life and have indeed, again, less scientific data to back them up. MPAs normally will be managed in the deep water areas also from the national level, while local MBAs may be managed regionally or even locally. Finally, the high seas connection management tools for MPAs within national jurisdiction need to be complementary to those outside the jurisdiction, again, because of the cross influences. And I will briefly show a slide on ideas there later. Then we have the more social issues of management. We have multiple stakeholders. Almost every government agency has some legitimate interest in a coastal or island country, from mining to fisheries to navigation, disaster relief to Coast Guard to public health. Some entities have responsibilities under international law, and there could be interest from the NGO community, the business community, of course, in fishing or tourism, and indigenous and local communities. The property rights are maybe quite complex, as many coastal areas with marine resources have property rights that for indigenous fishing, marine harvesting, maybe even some resource use ownership rights. These may be indigenous, commercial, or held by communities or corporations. I want to briefly go then to international law as another special feature for our MPA guidance. We know that the law of the sea is the main global treaty governing the oceans and state responsibilities. It has obligations that are laid out in the convention. These are the articles. You can look at them yourself. They focus on controlling pollution as well as protecting ecosystems. I want to make sure we're not having connection difficulties. Diego, is this coming through okay?
Yes, Barbara, we are okay now. Perfect.
Okay, good. We also have, with the law of the sea, importantly and newly for MPA law, the definition of ocean zones. The most important ones for national protected areas would be territorial seas, exclusive economic zone, and the continental shelf. And I will go into those more later. Then in the international oceans law category, we have maritime environmental conventions under the IMO. I just want to mention two protected areas classifications: the particularly sensitive sea areas, PSSAs, which are designated after special criteria are met by IMO to receive special protection from international shipping, where their area is significant for ecological or scientific attributes and the shipping lanes should not be going through. Then there are special areas. This is mainly, again, areas that need protection, but this time from pollution from shipping and the sea. This is under MARPOL, the Pollution Convention on Prevention of Pollution from Ships, and it covers accidental and operational oil pollution, air pollution, as well as pollution of chemicals, sewage, and garbage. Now let's come to our favorite convention, at least for me, and for us working in protected areas law, the Convention on Biodiversity. It meant in many decisions that the parties have made have set forth definitions, criteria, goals related to MPAs that should be reflected in national legislation. First of all, Article 2 of the Convention actually includes marine and aquatic systems within its biological diversity definition and defines MPAs and MPA networks, and I'll briefly go through that later. It also has guidance, particularly for marine and coastal biodiversity, starting with the 1998 program of work, which you all can find. This was updated in 2004 as part of the overall program of work on protected areas, and in 2008 was special guidance on marine and coastal protected areas and networks, which was a collaboration with the law of the sea. Finally, of course, we have our famous ACHI targets coming from the CBD, and I note again target 11 on expanding coverage. Briefly, other conservation conventions, and I'm not mentioning them all, but let me highlight several. The Ramsar Convention, the formal name being Convention on Wetlands of International Importance, and especially for waterfowl habitat. It defines wetlands to include areas of marine water, the depth of which at low tide does not exceed 6 meters. So clearly we are covering most coastal zones around the world. The World Heritage Convention in 1995 approved a World Heritage Marine Program to more aggressively promote the nomination of large-scale marine areas and networks, and this is very active. Then the Convention on Conservation of Migratory Species, which was covered in prior, especially webinar 3 on connectivity, which uses formal agreements and MOUs as main mechanisms, in this case, to protect the ranges of and the habitats of many marine species. There, of course, is there's regional and supranational law, many laws. These agreements get ratified by countries. They may contain obligations and other commitments important to take into account in an MPA legal framework. There are so many. I just want to mention 2 approaches here. One approach is agreements that directly call for MPAs. That could be bilateral or transboundary. And an example, a good example, I think, would be the Regional Seas Agreement launched originally, a program launched originally in 1974, which today has some 18 participating regions. You probably, listeners, are part of one of the regional programs of this initiative. I just mentioned the example of the wider Caribbean Regional Seas Program. Many have protocols on protected areas. This one has a protocol on specially protected areas and wildlife. The second approach is to have a general obligation to protect the marine environment, where one tool to implement the obligation is MPAs. Here I just want to mention the EU Natura 2000 project, an initiative also noted in webinar 3, which has been applied and extended to be implemented in member states' EEZs, thus requiring EU members to designate special areas of conservation, or SACs, in their EEZs and provide species protection in that zone. Also, just to mention, this isn't an international treaty, but it's an important program that when countries pledge to be involved, they also pledge to undertake protections as best they can that are sustainable, and this includes legal protections. This is the UNESCO Man in the Biosphere program, which has biosphere reserves. The network includes marine and coastal biosphere reserves, and again provides guidance on legal elements. This is what I want to emphasize in the second part of the webinar here on special features in international law. I would like to move on to the most substantive part, special legal considerations for MPAs in light of these features. Here I have tried to cluster these special legal considerations as a legal drafter, look at them in a protected areas legal framework. There are 3 fundamental clusters. One is preliminary provisions, which are the underpinnings, or sort of the defining elements that help us figure out how to implement what we need to do. Then substantive legal provisions, which are what we need to do. Then the tools for implementation that give us aids on how we actually go about working on to achieve the substance, the policy, and the objectives. I'm clustering these because they also are interrelated within each of those 3 big categories. So I will go through those in clusters. First, let me briefly note, because as a legal drafter I can't avoid it, it's important to have preparations before one gets into the drafting process or the review process. First, one must consult with interested agencies, scientists, technical experts, and stakeholders to understand what's happening with the existing framework and areas they feel are working and not working. the existing legal framework itself needs to be understood, and not only the provisions that are there, but also any customary and traditional practices or rights, main institutions and their capacities existing wise, and governance approaches that may be there, whether they're working or not, including management or co-management. Finally, it's important to be clear on objectives and understand the overall goals for the new legislation in light of what already exists. Now, options for the legislative approach are basically four. One can have an umbrella law using one instrument for all sites. This could be subsumed within an overall protected areas law as a chapter or a part, or it could be a separate umbrella MPA law. You could have site-specific laws, particularly where a site is large or there's a group of sites that have some common element. One example here is the Great Barrier Reef, which has a special law. You could have species-specific laws that track habitat and life cycle areas, marine mammals, for example. Or you could have some combination with some large and distinct sites, some other sites that are specific, plus you need an overall MPA framework. Let's go to the preliminary provisions that I think are important to quickly review as elements for MPA law. Policy, of course, we start with that. It's to guide the content, to help provide a vision, a mission, and goals for the country, for decision makers, for the users. The National Marine Conservation Policy, if there is one, is an important element to include as a reference or as a side document in your protected areas law, in your MPA law. Ideally, there will be an explicit document that's either national or subnational. On the other hand, if there isn't, one may go to other sources. In this case, particularly, for example, hopefully there is a really good policy statement on marine conservation in NBSAPs, or more generally in sustainable development strategies. Examples of a network of MPA examples could include emphasizing a network of MPAs, that it's comprehensive and representative, that it gives priority to rare and unique species, and includes connectivity. Then objectives, and this gets a little more meaty. We have here legal provisions that help to actually guide decision making on implementation for the substantive provisions. This is important because it should be clear and comprehensive if needed, because it will be a measure to judge accountability, performance, effectiveness of decisions taken, and also probably will be an instrument for judicial review if there are legal challenges. International guidance is available on some objectives, particularly if one is party to an international convention related to MPAs. Of course, I mentioned the ACHI targets, and in this case, we could have the objective of 10% coverage, as well as some of the other ACHI target goals noted in webinar 2. Network objectives could include accommodating the full range of conservation sites and management categories, recognizing the full range of governance approaches, providing connectivity, using best available science. Then as site-specific objectives, you could get to individual sites or ecosystem priorities, restoring a particular or protecting a particular scientifically important ecosystem, such as a coral reef or biodiversity hotspots or tidal basins, conserving sites in high biodiversity, protecting specific sites of international importance. Finally, key definitions here. It's important to have a distinct section because MPA law is a bit technical sometimes, and particularly implementation as one moves to regulations. So it's important to have a section with terms that are necessary and central to the application of law because of their special scientific, technical, or other particular meaning. For example, the definition of biodiversity. You don't want to over-define though, because if you define terms in a way that the definition uses other terms that need definition, then you're having confusion. So Try not to load too much in your definitions. Keep it essential and look to international definitions, not only biodiversity from the CBD, but perhaps also wetlands from WebSAR or the ocean zones from the Law of the Sea. I want to give the example of an MPA definition internationally, as I mentioned I would. IUCN uses the generic protected areas definition, clearly defined geographic space, recognized, dedicated, and managed through legal and other means to achieve the long-term conservation of nature with associated ecosystem services and cultural values. Now, there was discussion about this and whether it should be generic or specific to MPAs, and the decision was made that the definition needed to link with terrestrial protected areas, and it would distinguish more clearly between conservation-focused sites and those where the primary purpose is extraction. So this gives a harmonious definition throughout the country and all ecosystem types. CBD has a similar definition, again recognizing the need for legislation or other effective means to protect over the long term. Just to mention quickly, essential considerations for both of these definitions is that conservation is the primary objective, and to be recognized as an MPA in the World Database on Protected Areas, generally the IUCN definition is with or the primary objective of conservation is needed, and the IUCN definition is meant to apply across all management categories. So the World Database includes that where the countries provide it. Jurisdictional definitions are another new aspect for marine protected areas. There is marine water under national jurisdiction, coastal marine areas, and deep water marine areas. In the marine areas under national jurisdiction, we do have these new definitions under the Law of the Sea. Territorial sea out 12 miles, the EEZ 200 nautical miles beyond that. This actually significantly expands the rights and obligations of the states. And it is important for MPA legislation to be clear that MPAs may be created to the limit of their declared EEZ, where that is the intention. Now we have the continental shelf, where in some countries may extend beyond the EEZ, and in that case, again, legal provisions may want to take this extended limit and recognize it for MPAs. The coastal and nearshore marine area has its own particular components. This is the area where traditionally most of our marine protected areas have existed. It extends out to the limit of the territorial sea. It has considerations with respect to agencies and laws and stakeholder groups that are separate from deep water marine areas. Beyond the territorial sea is deep water marine conservation areas, and these are areas where scientific understanding is less likely to be as complete as in the coastal zone, and there are different considerations for management, enforcement, and stakeholders. Institutional arrangements come in as part of this category of provisions. We should be looking at in the law or in some supporting document declaring who has overall responsibility at the policy level, typically is the minister, head of state, or other separate ministerial unit handling marine or other matters. Where the terrestrial and marine areas are under different policy bodies, it is a good idea sometimes to have a high-level policy body for coordination. The lead MPA authority is this second level. This is the technical unit that is responsible for day-to-day implementation. It should be specialized. It may be at a national level where the network and the sites can be managed together. It may need to be separate authorities for different sites depending on how complicated and diverse those sites are. Sometimes this agency will be a statutory corporation rather than a national department. Management institutions, again, following a bit the issue of the management MPA authority, there could be a single authority where there are a few sites or it's possible to manage clearly. There could be individual units for specific sites where even under umbrella legislation or separate legislation, you have dedicated authority. This is an example, one can say, in the Marine Barrier Reef Marine Park Authority. Then there's transboundary management, as was covered in webinar 3, the issue where countries may want to harmonize their MPAs across borders, may need separate transboundary management arrangements, and this could be authorized in legislation, but probably would come outside the legislation. Levels of management could be central units, as in a centralized form of government, decentralized units in a federal or decentralized form of governments, in which case there may be parallel entities with some responsibilities at the national level and others at the state level. And of course, there could be non-state actors, indigenous groups, communities, NGOs, or local corporations. Here, legal provisions should authorize the possibility that these entities could be designated by agreement to manage particular sites, either as co-managers or sole managers, and then you'd want conditions and incentives and support mechanisms. Finally, support mechanisms are particularly important. Marine protected areas and marine environments have so many different sectors involved. They need to coordinate with terrestrial areas. There are sector laws themselves that may be overlapping and conflicting. Within the protected areas regime, there may be different laws, and you may have diverse governance types. The kinds of coordination mechanisms one might use could include advisory committees or commissions or groups that are both permanent or ad hoc. They could be advising on a scientific level. They could be advising for governance and stakeholder issues. There could be special user groups, for example, working together with cooperatives of fishers. Some groups could be organized for data collection and monitoring, as well as education. That covers our preliminary. Let's go quickly to our substantive provisions in law. Starting with strategic planning, if possible, an element that should be in the law where a provision could call for development and regular updating of a strategic plan. This could and should have as its goal building networks of representative marine and coastal protected areas and accommodating the special features of marine areas. A strategic plan would want to be identifying resources that could go and be used for the most highly valued sites. Of course, the content would depend on the plan, but ideally it would include existing and future priority sites, connectivity, and governance. Establishment is a second aspect of substantive law that would be in MPA legal frameworks. Here, the first important thing is to look at scale. You want to have a size that minimizes adverse impacts from activities outside. And actually, scientists promote the establishment of a few large sites rather than several small ones to provide for better connectivity and management. You have no-take zones. This is really a call from the CBD program of work for a balanced mix of highly protected MPAs where extractive activities would be permanently prohibited and others where there may be sustainable use on a controlled basis. You want a provision on interim protection because in not all cases may you have sufficient data to do detailed management, but you need to designate to protect them now. You want straight and simple boundaries for the most part because you won't see anything easily marked on the ocean, so you have to have something in a nautical chart. Using best available science and technology includes giving authority to have new technologies available, and given credit in a judicial sense if there's prosecutions, including remote sensing, global positioning, and satellite tracking. You want to account for adaptation, of course, to take into account global change and shifts that may occur in your boundaries. Management then, of course, as with protected areas generically, management categories apply to the marine environment. You need a management plan for the marine environment, and these are covered quite well in the course materials. Zoning plans are an important tool here, especially to address issues of scale and special management needs and no-take requirements and buffer zones. And buffer zones are needed because especially you need to look at the connectivity needs and environmental variability. Then again, adaptive management is important to include in the management plan. This involves some flexibility, but where adaptive management requires suddenly changing legally established boundaries, legislative amendments would be required. Then governance, which covers all of these three areas. Of course, stakeholder participation is important. The use and recognition to use diverse governance types apart from state-owned and state-controlled MPAs to indigenous, local communities, private NGOs. The locally managed marine areas, popularly being promoted in much of the literature by local communities, is a favorite example under governance, and co-management and voluntary agreements are definitely needed when one is working with this. These are covered in depth were covered in webinar 1. I am not going to go over this, but there have been questions from time to time on whether MPAs actually have standards. And this is a scientific guidance instrument coming out of the CBD that occurred in 2008 in a collaborative work with the UN Law of the Sea, that's basically looking at the important elements where marine protected areas in the high seas and within national jurisdiction have to come together commonly. And this is the special feature that I mentioned earlier on the kinds of guidance important for establishment. Tools for establishment. The third big cluster of provisions for our law. Regulation starts the process and is the traditional tool. It is used to safeguard objectives and to prevent unlawful activities, of course, because this is an enforcement tool with potentially criminal implications. Law is needed. There are 3 types. These are common across most laws. Prohibitions, where you would strictly prohibit an activity because it threatens the conservation objectives. This would be dumping, taking rare species, destroying critical habitat. There are general rules which may not need to be published individually, but could be with handouts and maps where the public can see where they can snorkel and dive and fish. And these are associated with public use typically. There are then the regulations that require permission, otherwise they're prohibited. And this would be in order to control the activity and make sure it's got the right kind of management controls. Docking cruise ships, ecosystem companies, dive operators, fishing charters. And these are down here in my 4th bullet, sort of key areas for regulation. The fishing in no-take zones should be absolutely prohibited, of course. There may be in other zones, particularly recreational fishing and artisanal fishing authorized. Tourism is one of the activities that needs to be conducted and managed and regulated in a way that's ecologically sustainable with regulations, whether specific or general. And because this is an area of growth, without proper regulation, tourism especially can lead to overuse and abuse in some of the important beaches and recreational areas and coral reefs. Biodiversity prospecting would not be allowed within an MPA, but it's an area of growing interest and activity. So if it ends up being licensed in a nearby marine water, legal provisions should provide strong controls and safeguards, including using international standards so there's minimum impact to the area. Finally, scientific research should be strictly controlled by permit. In some jurisdictions, marine research in an MPA is one of the major activities after fisheries requiring oversight and control. Promoting compliance, this is the ideal, isn't it? Because we have such vast areas and important management needs. This requires building strong awareness among stakeholders with educational tools. Two areas that the legislation can give attention to is authorizing officers to have enforcement and interpretive responsibilities and surveillance from the community, and partnering with these local communities for surveillance, monitoring, and data collection. Of course, this involves training. Then there's an enforcement and surveillance. Widely dispersed areas have and special equipment needs and special training needs and extreme weather are all the special challenges that are facing enforcement and surveillance in the marine environment. So I mention here, highlighting especially the kinds of tools that are required that need actually in many cases attention in the legislation to give authority for them to be used, and particularly used in evidence for prosecution. So here you're looking at remote sensing, satellite imagery, GPS to accurately identify whether vessels are illegally inside boundaries, onboard transponders, and other data technologies that can link to specific pollutants at a site. Without going into detail, I just mentioned this to you all for interest if you want to go into it more. This is one of our case studies from the course materials and the guidelines of Protected Areas Law, which is a deep water port in Canada under the Canadian Oceans Act, and they use this modern technology. It's very interesting to learn about that. Another example, this time from a protected area in the South Pacific, where straight and simple boundaries clearly are illustrated. This is, I mention it also because this is a UNESCO World Heritage Site, the largest and deepest site, marine heritage site on Earth right now. It was established and it was declared in 2010. It is in Kiribati, and it is a IUCN Category 1. Financing, very briefly before we go on to connectivity. Of course, the law and the legal and financial mechanisms supporting the law need to recognize the importance of core funding from general revenues to reflect the commitment of the government and to make sure there's government control. In addition, collecting fees should be authorized through special permits for events, for certain archaeological treasure hunting, for scientific research. And you may think about as designating a portion of industrial fishing licenses to support MPRs because of their role in sustaining the fishery. You can have public-private partnerships that might be authorized where NGOs and university programs, especially private sector interests, take a role in adopting a site or a habitat, do fundraising, cost sharing, data collection, or supporting scientific monitoring. Then there are special funds. I want to mention at the national level, legislation could create a special fund. For example, the South Africa Marine Living Resources Fund, established under their Marine Living Resources Act, which receives funds from levies on fish products and license fees, and then goes from the central government to the protected area system. And then there's a global fund that's just an investment fund that's just been set up under the World Conservation Congress, called the New Coalition for Private Investment in Conservation, with Credit Suisse, TNC, and IUCN and Cornell University as founding partners. They're just getting started. It'll be interesting to watch. Here we finished, and in a rush, our special legal considerations. I would like to now go quickly to marine connectivity. What is marine connectivity? Well, this is one of my favorite illustrations. It's in the Gulf of Mexico where I reside. The arrows show currents and movement of marine life. Marine life and especially different fish stocks move through the Gulf during different stages of their life cycle. And this illustrates sort of a connectivity concept within the marine environment in this particular sea. Getting more scientific, knowledge about connectivity in marine systems is much less advanced than for terrestrial systems because the subject is relatively new. But with the help of new technologies such as satellite imaging and tracking of marine mammals, we are improving our scientific understanding. The two main scientific approaches are first between populations, which has an emphasis on species and their movements. It considers species at all stages of their life cycle, including eggs, larvae, juveniles, and adults. The second approach is between sites, which focuses on the movement and connectivity of nutrients, sediments, pollution, and other items in the marine and coastal environments. Now, there are special challenges with these efforts because of the special features of the marine environment. Understanding what is happening in the oceans and with its marine life, ecologically and even genetically, needs to take into account such factors as different seafloor and nearshore characteristics, different water masses, different oceans, the Arctic, the North Atlantic, different sea currents and ocean density, like temperature, salinity, and pressure. How it happens is on this slide. The marine connectivity process occurs in many ways as marine species interact and ecosystems function throughout networks and across the marine environment. The connections of adjacent and continuous habitats such as coral reefs and seabed authorities or mangroves and seagrass nursery areas may occur. There may also be regular larval dispersal in the water column between and within MPA sites. There may be regular settlement of larvae from one MPA to another that promotes population sustainability. And there may be movements of marine life in their home range from one site to another or because of regular or random spillover effects. I want to mention these two illustrations here, these pictures. The top one is tracking by satellite the leatherback sea turtle migration movement across the mostly Atlantic, southern and northern Atlantic in this case. It shows signals from the tagged whales. The bottom picture is shows coral larvae dispersal patterns in the Flower Garden Banks National Marine Sanctuary in the Gulf of Mexico. These patterns can be used to estimate distance ranges for consideration in MPA design. I'm not going to go through this slide. Again, we went through the international law generally above. The same instruments roughly that we talked about there, supporting marine MPAs, support marine connectivity, and you can look at this at your leisure. The last two slides here I want to focus on relate to international law provisions that can specifically support marine connectivity. The first are traditional provisions, which we've had for a couple of decades now, marine protected area networks and ecosystem-based management. The international guidance we get on MPA networks comes from IUCN, seeking to maximize and enhance linkages among individual MPAs and groups of MPAs, and then national guidance where legal provision should require sites to be designated and managed as part of an overall framework of MPAs, and connectivity expressly to be taken into account. The ecosystem management concept gives broader attention to ocean processes and lakes and land-sea interactions. Of course, this is inherently a connectivity element. It incorporates resiliency considerations and adaptability for climate change, and also may cross maritime zones as as ecosystem processes and marine life flow between the national and high seas areas. This is an element that also should be recognized in legislation in relation to assessing connectivities of the MPA network. Finally, this is a very important slide, and it's one I will try to spend a minute or two on, and we can follow up with questions. 4 specific laws or policy tools for area-based management in marine environments are the following. Large marine ecosystems. These are concepts that have been around for some 30 years, started as an system approach to assessing, managing, recovering, and sustaining really transnational ecosystem processes and resources. Today, there are 66 large marine ecosystems defined globally that may extend to the EEZs. They normally are areas that are highly productive, more productive than the high seas. Countries participating may have special legal obligations that need support in national legislation. And the UNEP and IOC of UNESCO monitor and actively manage sites for the individual areas as well as overall. And I just mentioned the Gulf of Mexico large marine ecosystem site with its strategic plan. Marine spatial planning, here the emphasis is on comprehensive planning, large-scale planning, incorporating ecological, economic, and social considerations. Usually you need law to provide, or some kind of legal instrument to provide authority and guidance. The connectivity elements are, of course, essential here. The process involved is usually quite heavy in stakeholder participation and consultation. The tools produced are normally maps. These are to be used in a cooperative way based upon existing legislation. There is no new legislation, but existing laws are used to provide the authority to the extent they can. Ocean zoning then takes the marine spatial planning to the next level, ideally using marine spatial planning maps. It provides a zoning map for single or mixed uses or multiple uses. It identifies conflicting uses, existing and future needs, such as wind turbine energy, thermal energy plants in the ocean. It produces maps. These maps need to be ecologically and sensitive to the environmental characteristics of the region, as well as economic and the user needs. There needs to be a cost and benefit analysis of this because it involves new regulation, which means new legal provisions and justification for that. Finally, coastal zone management. The integrated coastal zone management concept, sometimes simply called integrated coastal zone management itself without the oceans in it, but it includes the oceans, began to be incorporated in legislation in the 1970s. It is a broader concept. Its main feature is to be a framework to manage the whole coastal zone, both land and sea, using an ecosystem approach rather than a fragmented sector by sector approach. And remember, it's important to think that coastal zones under our new regime go to the territorial sea line. Coastal zones should be defined for this to work, and the inland limit should be defined as well as the outer limit. Scientists are more and more emphasizing the importance of including MPAs within the coastal zone, coastal and ocean zone management framework. And this is because not only this helps ensure broader protection of biodiversity and connectivity with attention to climate change and other threats, it also would have MPA management be part of this broader governance regime. So these are the 4 points that I wanted to cover. I hope they are beginning for you all to become interested in exploring more. Again, I want to review the reference materials. There is quite a bit of detail. And in the guidelines for protected areas law, I actually include language that can be used as reference for different kinds of considerations and provisions. So there is quite a bit to use as reference. And with this, I want to thank you all, and I want to thank Diego and UNDP for, again, managing this process and taking the initiative to help us focus on these important legal areas.
Many thanks, Barbara. This is a really interesting and relevant topic for our NBSAP forum members. I am sure our audience enjoyed the presentation and the complete webinar series in March. I want to invite our participants to share your questions, doubts, and comments, or raise your hand to participate in the Q&A session. Please use the control panel of the GoToWebinar platform that you have in your screen. We can open your microphones or read your question depending on your preference. I'm going to read some questions then, but I would like to invite our participants to don't be shy and please share your questions through the control panel in GoToWebinar. One of the first questions, there are so many sectors involved with marine activities and thus affecting potentially marine conservation. How does one help ensure integration and collaboration?
Thank you. Thank you for the question. There are two ways, of course. I mentioned in the sort of substantive provisions and as well in the institutional mechanisms, the critical importance of support elements. And this is especially the case in the marine environment because we have both coastal agencies and sectors with their own laws, as well as the marine environment beyond the territorial sea. If it is possible to form collaborative committees, that would be an administrative approach. And I think as different sectors and user groups appreciate the role that MPAs play in the bigger picture and also how they might be able to benefit and make that particular program better, I think there might be interest, but there has to be a concrete initiative on the part of the highest policy level, it seems to me, to call this kind of informal collaborative committee together for regular activity or regular interaction. Another form, of course, is a subcommittee of a cabinet. Now, there can be formal requirements in legislation that also say that certain things take priority and that there shall be a coordinating mechanism that is a permanent mechanism. And then there could be rules and administrative procedures, how that permanent mechanism operates, functioning both under the minister and then with probably the secretariat, the technical advisor being the MPA authority. These are particularly challenging issues now as we advance into the marine environment and we learn more scientifically about some of the complexities of management.
Thank you, Barbara. We have a hand raised by Joy Garner. I'm going to open the microphone. Hello, can you hear us?
Yes, good morning, and thank you, Barbara, for an excellent presentation and for the additional materials. On the issue of limited scientific knowledge, some of the regional agreements, and just for additional information, I'm actually in the Caribbean and referring specifically to the Protocol on Special Protected Areas and Wildlife under the Cartagena Convention. There's a requirement for a criterion for listing that speaks to the issue of one, connectivity, but also resilience. And I just wondered, given the state of knowledge at this point in time, how you would address, how you would suggest we address issues of resilience and the precautionary principle within this sort of legal framework? Would you suggest it in policy, in regs, or in some kind of agency guidance or some other mechanism? Thank you.
Yes, thank you, Lloyd, for this question. You've really touched on a very difficult subject, partly because the term resilience isn't well defined and not commonly understood. Depending on which sector you're in or which scientific area you're working in, resilience may have different definitions and implications. Let me refer a little bit to what's happening in the Gulf of Mexico, because there is a Gulf of Mexico alliance with the 5 states, and they have put together different tools for decision makers and scientists to use to help deal with climate change. Resilience has become a key element, and it's become an administrative element, actually, where a subgroup has come together and produced a bit of a, not too long, a bit of a survey on resilience indicators in different areas. Some are natural environment resilience factors, some are the built environment resilience factors, and then some are short-term and some are long-term. Remember, in climate change, we need to be thinking at least a 50 to 75-year planning horizon. That in itself integrates a lot of caution, because we may not know today what we know in 50 years. So the scientific issue, this issue of scientific uncertainty comes up. And that brings the precautionary principle. As we know, the precautionary principle is a fundamental principle, and also in decision making, in international law and guidance, and also highly recommended for inclusion in marine protected areas as a way, particularly to guide establishment, as well as adaptation and management. So I would say that include the precautionary principle in any guidance formally that comes out of SPA. There may be a subgroup that could meet. I know that there are many subgroups within the Cartagena Convention that work with management plans for different species. One could have a planning process for this issue for climate and resilience, and then look to what's happening elsewhere. And I can help you. I can feed some of these forms to you on different kinds of resilience frameworks and reports that come out on how they're being handled in natural and built environments and near and long term.
Yeah, thank you.
Does this help?
Yes, it does. Thank you.
Okay.
Thank you, Barbara. We have a question by Kosi Besam. I'm going to open the microphone. Are you there? Can you hear us? We have some problems with the audio. I'm going to read the question. The question is, did African countries knew all this law? How this law can protect African marine ecosystems while policymakers haven't had any background?
Very, very good. There are of course the tools that we have. Is it okay?
Yeah, go ahead. Sorry.
There are the tools that we have online through the IUCN Environmental Law Center Protected Areas Law website. Some of these tools also can be broken down into pieces. We created those modules so they could be condensed in for like a 2-hour seminar. Now it takes a little bit of help to do that, but we can help with that. Also, the regional offices of IUCN in Africa, mostly managed by the World and guided by the World Commission on Protected Areas, and a program called BioPAMA, have been providing some training to African leaders and government officials on these guidelines. In addition, when one is a focal point in any country, including Africa, for the CBD and UNDP have conservation training modules that are online. They're self-paced, they're e-learning classes, they're free, one registers, but then one goes through these modules and they're very straightforward. I have done the 2 modules on protected areas law. The first, introducing protected areas law in general terms, most of the elements of which apply to MPAs, and the second on special issues, including marine protected areas, transboundary, and connectivity. I would encourage folks to go to these different tools. Also, we did a case study under the connectivity, under the general guidelines for protected areas law, as well as under the connectivity guidelines. And there was a case study in each of those publications for South Africa. The case study of the national law for protected areas for South Africa is exceptional. It covers the entire range of terrestrial to marine. And then the particular case that we have from South Africa for the connectivity component is relating to the greater Cedarburg biodiversity corridor. Each of these case studies was prepared by a local legal expert. And in fact, my colleague who produced webinar number 1. And I would strongly encourage you, you can go online, you can get these case studies, you can work with Dr. Patterson. I hope I'm not overextending myself. And also begin to work with these training tools in a simplified form to help policymakers understand this is not only a commitment, but also a new policy direction to really help us meet global and national goals in biodiversity conservation.
Thank you, Barbara. I just want to remind that you can send your question or raise your hand in the control panel of your GoToWebinar. We have another question by Moha Hadouk. The question is, are there any sources for georeferenced maps showing MPA worldwide? Moha, can you hear us?
Yes, I hear you. Thank you very much. Yeah. You hear me?
Yes, I can. Thanks for the question. I believe, and I might try to find some for you. I believe there are some maps, but you know, if one looks at a global map, the definition is going to be quite tiny when you see the dots. The World Commission on Protected Areas database on protected areas has a website for marine protected areas and also transboundary protected areas. To the extent that the countries provide, it also indicates the categories, the different categories of IUCN protected areas management 1 through 6 that these MPAs or their zones have. There are also maps showing the large marine ecosystem areas, and there are also maps just generally showing coverage. I could try to help you find some. If you will send your email address to Diego, I can quickly forward you the large marine ecosystem maps, and because I know that's updated regularly by IOC UNESCO. And I think also find for you the regional seas agreement maps. And many countries belong to these. Some are less active, some are more active.
Yeah, thank you very much. I have just sent you my email, and they will appreciate it. Some maps on large marine ecosystem areas. Thank you very much.
Okay, super.
Okay, we have another question. How do you see international funding for MPAs evolving?
Well, it's quite interesting. The issue of funding is coming up now in the private sector, which I guess isn't too curious as one begins to appreciate that fisheries are endangered, and that's a strong economic activity, and seabed mining is also coming back, and there's ocean oil and gas exploration and stuff. I don't know where the investment issue is going to go with global funds, but there are two initiatives. I didn't really mention them in much detail. Let me see if I can find them here. One is this new coalition that I mentioned on that happened at the World Conservation Congress, and that is made up of the partners that I indicated. The other one is a new initiative coming out of Conservation International and the Environmental Defense Fund, which is putting together what they call a Sustainable Oceans Fund. I haven't, it is brand new also, I haven't got information on it yet. But so those are new initiatives. It's curious because I am assuming they're going to try to find private investors, but then the issue is going to be how they capitalize on resources that can produce some kind of an economic value, which brings in natural capital and requires a lot of attention to longer-term economic analysis of the broader benefits of marine conservation and maintaining solid ecosystem health, sustainable marine life, this kind of thing. I will say also, perhaps you are aware that the Global Environment Facility, under its responsibility with the Convention on Biodiversity, has as a major area conservation grants for biodiversity conservation. And that could conceivably include both national and regional initiatives in marine protected areas. I believe it is funding some of the large marine ecosystem work. I think that it is funding some of the collective marine protected area work, including legislation and governance in the South Pacific. So that is another established area. Bilateral funds may happen, but that's going to be dependent upon the relationship of the country to the bilateral agency. It's a difficult area. Financing in general is a new topic that the Law Center has begun to tackle in the context of protected areas law. It's formed a working group with economists and people who can analyze long-term economic benefits of marine conservation, with, of course, then lawyers and others who can help identify how it fits into protected areas and related financial legal frameworks. But it's this is a challenge, and this is really a topic to watch, I think, in newsletters and in general news items in your various networks.
Thank you, Barbara. We have our hand raised by Banteyun Tesasu. Hold on. Can you hear us?
Yes. My question is, the sustainable maintenance of the ecosystem is tied to actually poverty in developing countries. People inadvertently affect, deforest, and inappropriately use the marine resources for survival reasons. Now, if these people are enabled with the appropriate tools and methods, then they will be effectively using the resources, or efficiently using resources, for example, using less land to do their survival, their agriculture, and so on. How can this be applied into the policy design so that really it's a win-win for both the people, the environment, and probably some investors that are peeking into this kind of activity?
Yeah, thank you. This is a really important question, and this really triggers the issues of governance, doesn't it? Because we've had traditional approaches, and in fact, because many marine areas are truly in the public domain and are considered that way, we think less of governance sometimes in the marine and coastal environment than we do in the terrestrial environment. But it's quite interesting. When I worked with governance in the guidelines, I became very involved with the ICCA, and they're helping me understand that local communities and indigenous groups may have fishing rights in distant waters. They may have coastal rights. There may be cooperatives, and these communities need to be recognized more in the whole policy framework, and in the entire cluster of activities that, for example, an MPA law would authorize, helping people be involved in planning and recognizing that a planning exercise involves local stakeholders that include users and people with traditional and maybe customary rights who have extensive knowledge about the cycles, ups and downs of the various resources they're managing and using on a sustainable basis. This also includes their involvement in establishment, because they can help understand the management categories that may be needed or the zones that may be needed. And then in management itself, we don't need to have local and indigenous communities always just self-managing. There can be co-management where scientists can be brought in. And this really needs to be the kind of perspective that the legal framework recognizes in order for people's ideas to be triggered, in order for processes to be opened up, so that the scientists can come in, they can learn from the people can learn from the scientists. We call this sort of local integrated knowledge circulation. And more, this is what I'm working on now, because we know that people depend on the sea, and we want that dependence to be sustained so they can have livelihoods, preserve their culture. So I know this is a general answer, but I really see, and I can envision, as one works through provisions of a law, that there are elements for this kind of broad participation by the people involved. There are conservation agreements, and there are a lot of examples of conservation agreements now, so we can understand better how one defines the rights and the responsibilities of all parties, and how we can get benefits and incentives to the local people to be involved and not be afraid. So there's always the chance of paying for their environmental services, as was mentioned in the webinar 3, but we need much broader involvement on a sustainable basis, both to keep the communities going and to keep our resources healthy.
That would be nice if awareness is given priority to enlighten the individuals over there.
Absolutely, absolutely. And this is the other thing. We, in our particular protected areas law courses, our focus is on decision makers and leaders. But some of these leaders could be community leaders, and they don't need to get all the detail, but they could, you know, with a little bit of cross education and participation in consultative groups and seminars, they could be informed about and trained in roles to participate and how to participate. This is all part of broadening up democracies and sort of local governance approaches that make for good governance in the end. But you're right, building awareness is the first thing. People are afraid to participate or unaware.
Thank you.
Thank you. We have one hand raised and one question, but we don't have too much time, so I'm going to open the microphone for Pata Shanshihashvili. Can you hear us? Hello? No, it seems like we have some problems with the audio. I'm going to read the question then. Hold on. The question is from Lucelena Escobar. Thank you for the presentation. In your opinion, the local communities should be participated in the regulation about the conservation and use of the resources in the high seas? Or the local communities only should be participated in the legislation about the marine areas over the country that has the jurisdiction?
Thank you very much for your question. You know, the high seas are outside national jurisdiction in principle for any national party, except within the framework of the Law of the Sea Convention, its various working groups and initiatives now to work more with the high seas and protected areas. I think that local communities, for the most part, want to be and need to be and are most interested in being involved in coastal and marine areas within national jurisdiction. Now, some countries have not had EEZs recognized, but most have. And to the extent that's the case, my sense is that local communities could even be involved in participating as much as they feel they can contribute, even in deep water MPA development. They may have, typically artisanal fishing and traditional fishing communities will have rights out to maybe 5 miles or 8 miles. But now we're talking, that's just still within the territorial sea. So for sure they should participate there because they're going to be directly impacted. But they may have very long historical records of areas beyond the territorial sea where there were from time to time extended water ventures in fishing or ceremonial events. And there they would be appropriate, it seems to me, to participate. But basically, their participation should focus on a healthy and effective exchange and ongoing involvement within their national waters.
Many thanks, Barbara. Unfortunately, the time is over. Many thanks again for your time, and thank you everybody for your participation in this webinar. Barbara, please share us your final remarks on the topic, or if you have any recommendation or suggestion for our audience to get more information on this topic today.
Okay, thank you, Diego. First, thank you very much because you shepherded me through this process as with others. This was my first webinar. I also want to thank UNDP and all the participants for being interested. I have provided a few source materials that go beyond the guidelines and the courses that we've already highlighted. These include a couple of online newsletters that are global that deal with MPAs and marine ecosystem management areas. So I encourage people to look at that and maybe sign up for these free newsletters. One comes about every other month, and I'm always delighted to read it. In fact, this is where I found out the latest about some of this new investment funding initiative at a global scale for MPAs. Otherwise, I might note that the UNESCO Intergovernmental Oceanic Commission, IOC, has just released, as of last week, a joint roadmap to accelerate maritime and marine spatial planning processes worldwide. And this is jointly with the European Commission, but it has actions relating to maritime spatial planning. And I think this is reflecting how we are coming of age in the marine environment to begin to look at these bigger tools and understand ecosystem processes need sort of broad umbrella protection. So you can go onto their website and look it up directly, or I can send it to you if you give me your email. But that's just my latest news blurb on developments that we will continue to be pushing and amazed about. So thank you, everybody.
Thank you, Barbara, again. Please check out our website, the NBSAP forum, to get the list of the resources that Barbara is providing for this webinar session. Also remember that we will be publishing a PDF copy of this presentation, and the recording will be available in our YouTube channel, where you can also see all the sessions of our March webinar series. Stay tuned for our sessions in April. For more information, please visit our website, the NBSAP forum, or follow us in Facebook or Twitter. Remember, register or update your profile. Send us your thoughts on webinar topics you would like to discuss in the future sessions. And if you have questions on this particular session, please share it in the NBSAP forum thread that we are going to publish 48 hours after this webinar ends. I am Diego Ochoa from the NBSAP forum. Feel free to send us your comments, suggestions, and recommendations on topics you want to discuss for our future webinars. I really hope you all enjoyed this session, and please have a nice day, afternoon, or night, and hope to see you soon in the next webinar series of the NBSAP forum. Thank you very much, Barbara, again, and bye-bye, everybody.